Okay, all right, we got it. All right, good afternoon, everyone, and thank you all for joining us for today's a month of service presentation of wills and advanced legal planning and why do you need it? My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the a month of service collaboration. Also included, we have the City of Houston's Department of Neighborhoods, and joining us, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Jessie Campbell, who's going to be presenting the information for you this afternoon about wills and advanced legal planning. But also included in the partnership, we also have the Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, Texas Legal Services Center, the Earl Carl Institute, and Houston Volunteer Lawyers. And collectively, we all make up a month of service. And so basically, what a month of service is the collaboration of all of our organizations. We come together on a monthly basis and offer a variety of different workshops, resources, and information to the community relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. So we know that there are a lot of underserved communities out there that don't have access to a lot of information, don't know where to go for available resources that are for free or at a very low cost to them, and just don't know where to go when they need some type of assistance. So we decided to collaborate several years ago, and we came together and pooled a lot of our workshops and our programs so that we can collectively try to reach out and create a larger impact, reach more people by coming together. So we used to do these sessions in person, but of course, due to the pandemic, we did convert to the virtual platform. But we are trying to, however, get back out there and at least try to have hybrid presentations for you guys so that we can still reach out to the community that don't have access to computers and things of that nature, as well as still offer it online for those that are continuing to come back and join us virtually. So um, the information that we do provide for all of our presentations are not to be considered legal advice. We do this is for educational purposes only. We do want to encourage you to reach out to our legal service partners like Lone Star Legal Aid if you do find yourselves in need of any civil legal assistance. We do encourage you to apply for their services and do not automatically discount yourself and assume that you won't qualify because they do provide the services on an income basis. However, again, there are other resources that are available to you all as well. So do know that we are recording the session as well as broadcasting live on our social media platform on social YouTube as well as on Facebook. So we do encourage you to ask questions that you may have by either typing them into the chat or into the comment section, and we'll make sure that your questions get addressed at the end. You do have the opportunity to also unmute yourself and ask the question directly of Ms. Campbell. But do know again, as a reminder, we are recording and on live, so we do want to try to protect your privacy as much as we possibly can. So we ask that your questions to be as general as you can possibly get them, so that you don't divulge any personal detailed information. In addition to that, there are specific questions in regards to a particular circumstance that she just will not legally be able to answer for you guys. But she's going to go over all of that. There's a lot of information that's going to be covered here today. By no means do we expect you to be the legal experts by the time you leave, but at least you'll be a little bit more familiar with the process, be a little bit more comfortable with what kind of needs to be done prior to the passing of someone, and you know that your circumstance and your situation is not the same as everybody else's, and that there is a lot of misinformation that's out there that's not relative to the state of Texas, and I call it the street committee. Stop listening to the street committee out there and everybody kind of telling you their own version of their legal process or their legal understanding when they are not the experts. So which is why we do this presentation every month. We want to make sure that you get the most up-to-date information relative to Texas laws. So do keep that in mind as well. Again, a lot of information that's going to be covered. Feel free to go back and watch the recording of this as often as you like. Feel free to come back as often as you like to watch the live presentation or to ask whatever questions that it is that you have. So we do again want to thank you all for joining us this afternoon. We're going to go ahead with the introductions and get started with the presentation. So Ms. Cecile, would you like to introduce yourself?
Sure thing. Thank you, Nia, and thank you, everybody. Good afternoon. Thank you for all for being here, and thank you to our presenter partners. Thank you to Ms. Campbell for bringing this information. Like Nia said, this is valuable information that is coming straight from the experts. So make sure that you pass it along. If you know anybody that might need to hear this or might want to participate in our next meeting, share the link, let them know that we're here. We're here to share information with the community. I do want to let y'all know that on April 22nd, we will be having our Coffee and Conversation Resource Fair, and Lone Star Legal Aid will be there. So will the rest of us. So if you guys want to stop by, get some resources in person, and meet us all, we will be at the A-Leaf Multi-Service Center, or the A-Leaf Community Center. That is at 11903 Beller Boulevard on April 22nd from 10 to 12. It's open to the public. And again, we'll be there to meet y'all in person and maybe get you signed up for services. So without further ado, I'll pass it on to Miss Campbell.
Okay, Jesse.
Oh, excuse me. Good afternoon, everyone. Thank you so much for coming. Thank you for that introduction. My name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and I'm excited to have this conversation with you today on legal advance planning and why you need it. And so, a little bit more about who we are for Lone Star Legal Aid. We are a legal aid provider. We provide free legal services on civil legal matters to financially eligible households. And so we serve 72 counties in the eastern and Gulf Coast region of the state of Texas, in 4 counties in southwest Arkansas, all through 14 offices, including our headquarter office here in Houston, which is where I am. The financial eligibility for our clients is based on the size of the household, income, and assets. And so I can't give you like a dollar amount on what would make you eligible for services. But the estimates are as high as 30% of the state can qualify for services depending on different factors. And so I always tell people, don't assume that you may not qualify for services. There is always a possibility that you do. And again, we are civil legal services, which is consumer, employment, family, healthcare, housing, estate planning, probate. Those are just a few of the examples of the types of things that we help with. And, so don't, so if you need us, you know how to get us. All right. So, as Ms. Nia already mentioned, today's presentation is for educational purposes only. Please do not substitute anything I am saying as legal advice for your specific situation. As much as I try to talk about this in kind of a high level, big picture, what it applies to most people, it doesn't mean that everything I say is going to be exact to your situation. We do always recommend that if and when possible, that it is recommended to go speak with an attorney so that way you get advice that is specific to your situation and ensures that the documents that you are drafting meet your specific needs and so forth. Um, Again, just a reminder as it relates to the questions, this is a public forum. It's going to be on the internet. And the internet is forever, as they say. So please do not share any private information, either in the Zoom, if you are on the Zoom call, or if you are watching this via our streaming services on YouTube or Facebook. This is not the space to be asking us specifically things about, like, my mother passed away and this is what was in her will and I need to know if this is when I need to write my will, right? Like, we don't want that. Don't put anything out there where scammers and bad intended people can do something that you don't want them doing something with information that you are providing. In addition, I cannot provide legal advice in this presentation today. And so keep that in mind as you ask your questions. I can answer questions clarifying what we're talking about today, but if you're going to ask me about, like, what do I need to write because of X situation in my household, chances are I'm not going to be able to answer that. Typically, believe it or not, I usually need more information. That's the reason why it's all this individual planning. It's pretty rare that I can just get a one sentence question and be able to fully advise. And also, too, I'm just not allowed to. We are a grant funded organization, and there's rules on what we're allowed to do, and I have to determine you are eligible before I can provide any legal services. So hopefully, if you are interested, you can apply for services and I can help you at that point more specifically. All right. So what is today's agenda? We cover quite a bit today, and we can't cover everything. In fact, I would probably say if I was to do a full detailed estate planning trainings, we're probably looking at 6 to 8 hours probably total. So today is an introduction. It's an introduction to what is advanced planning, what is the definition of it, what it is, what types of documents we have, and why you need to have these documents and what you need to be thinking about as you are looking at these documents. And so we're going to talk about the types of advanced planning when it comes to legal advanced planning. Most people, when they think of advanced planning, they're usually thinking of estate planning. They're thinking about that type of thing. So we're going to be talking about planning for death, but there's also other types of long-term, other types of legal advanced planning. That's going to be planning for the care of yourself when you are no longer able to do so, caring for those in our care when we are no longer able to do so, as well as long-term care. And then lastly, we're going to talk about some resources that are coming up. So what is advanced planning? It sounds exactly what it is, right? Like, you also may hear it referred to as estate planning. It be used interchangeably by some attorneys. So estate planning, advanced planning, the same thing. I think advanced planning is a more accurate description of what we are doing because we're not talking about just planning for our estate. We're planning for things when we are no longer able to kind of handle things for ourselves, who's going to be handling it. And that's kind of in multiple situations. We're kind of anticipating a need before it arrives. And so that's what we're doing. We're planning for a legal need before it gets here. And so, but in general, what we are preparing and planning for is our death, what happens when we pass, what happens when we are no longer able to care for ourselves. So planning for incapacity. And then we're also talking about caring for those in our care. That can also have been used. You may have heard this described as family readiness. Family readiness typically is a little bit more focused on like support, like having family support. But it is going to be talking about planning when we are no longer able to plan for ourselves, incapacity, but also when we're not available, when we need someone's help, right? We need the village to kind of help us do what we need to do with those in our care. And so when we're talking about caring for those in our care, we're talking about minor children, those under the age of 18, adults living with disability under a guardianship, a formal guardianship, there's a court proceeding in place, as well as adults living with disabilities under informal care. We don't have a guardianship in place. There may be some discussions on how we can handle that when there's not a legal proceeding already in place there. We're also going to be talking about what long-term care is. Long-term care, we are living longer. And so there's some things we have to think about when we are looking into our elderly years and planning for potential legal things, legal issues that may arise as we age. And then kind of putting all of that into a legally binding written document. That's it. That's it in a nutshell. And the hope is that, you know, by the end of this, you're going to recognize what documents that you're going to need, and then to kind of move forward for it. Okay. So the other thing to make a distinction is that we are going to be talking about before. We are talking about before versus after. Advanced planning is that we are planning before the need arises, before whatever the situation is happens. And so, and then what happens after the situation arises can be very much dependent on what the document says. And if there is one, is there a document? And two, what does it say? And so what we do in the before impacts what happens in the after. The after is, again, very dependent on, does the document exist and what does it say? Sometimes there may be court proceedings required. Sometimes they're not. But the potential court proceedings that will arise in the after part is probate. When a person passes away, it's the probate process. Guardianship, when a person becomes permanently incapacitated, we don't believe that they will regain the capacity to care for themselves. And then when it comes to the care for our minor children, a potential suit there is a suit affecting the parent-child relationship as it relates to custody is the language that we're used to referring to it as. So that's kind of the distinction between that. Today we are talking only about the before, the planning. I will not be talking about the after part, the probate, the title clearing, what happens when we don't have documents and we need to do some things along that line. So we're not going to be talking about that today. At the very end, I'm going to let you know when that session is going to be. And so that way you can go and watch that video or that presentation, which will be in a week, that is going to talk more about the after part, what happens after a person passes away and what the work is that needs to be done in that. The other thing that we're not going to be talking about today is drafting the documents. So today we are focused very much on identifying the need, what the documents are, explaining what all of that is. But my part two, my second, this is a series, and the second part in this series of estate planning will be next month, and where I'm going to talk about specifically how you can utilize court approved pro se. That all that means is when you're drafting the documents yourself, you're representing yourself as pro se, how to draft your own documents if you decide you want to go down that route. And in that session, I talk a little bit more about the requirements in the document and things along that line. So kind of, you might want to schedule time to come visit me in May. So that's going to be kind of what the outline of today will be. All right, so first up, as it relates to our estate planning documents, is that it's an individual plan. All of it depends on what's going on, your family members and the dynamics. We wish we can say that all families are the same, but they are not, right? There are families that have different needs. You could have family members who are living with disabilities that we need to be thinking about. We may have family members that we're estranged from, that we are no longer in contact with, and we had falling outs, and we don't want them to be part of our advanced planning or part of our care. And so we need to be thinking about that. Where they live, like kind of where are they located? Are they available to do the work that needs to be done if they need to be able to step in? So a lot of it is going to be kind of very focused on like what's going on there. We're going to need looking at the type of property that is owned. That's going to impact what the needs are when it comes to the will. Who's in our care? Are they minor children? Are they adults living with under a guardianship, under our guardianship? As I already mentioned, right? So like, and then health conditions, not only ours as it relates to our own health and what that means as it relates to our our planning, but those that will be impacted by something that may happen to us when we are no longer available. What is their health condition? What are we thinking about, right? And so, and we got to be thinking about who's inheriting it and how is it going to impact them if there is going to be an impact. Can they care for that property? Should it, and so just kind of keep that in mind. And it's really important that we all kind of keep that in mind, that it is an individual plan, because you may be a two-parent, two-children household, and your neighbor may be a two-parent, two-children household, and they have hired an attorney to draft a will for them. You can't take their will and copy it down and use it, because their attorney would have asked them a lot of questions, would have had some meetings with them to talk about all of these individual dynamics. And so while the family may look on the surface to be the same, what you will not know is all of the unknowns, the private information that was only shared with the attorney when they were drafting the documents, and that may or may not apply in your situation. So you can't just go around copying other things. Even when I talk about the pro se documents next month, if you come to that, you will hear me talk about why it may not be appropriate in your situation depending on your individual needs. So just always kind of keep that in mind. We always have to be keeping in mind that what we need is what we need, not what other people need. So when should you be updating your documents? These are never one and dones. We change, right? Dynamics change. Things change as we grow, and things along that lines. And so you want to be sure that your documents are always up to date on what your specific individual needs are. And so we always kind of recommend that today, if you don't have documents, today's the day. Today's the day that you start thinking about getting your documents. This is when you are going to draft them. And I am one of those people that it does not matter to me. I'm of an age where I have friends who are lawyers whose children are now entering early adulthood and has been for a few years. And true stories, these are true, where my friends are giving the gift of estate planning to their 18-year-old children, and they're and these and they're the children are like, like, why do I need a will at 18? Everyone needs a will. Like, everyone needs these estate plan documents, because you just never know when things are going to happen. And then unfortunately, bad things happen, accidents happen, illnesses happen, and so you always want to be prepared. I'm always a fan of the idea of, like, when you're ready, then Murphy doesn't come knocking. Is when you're not ready is when Murphy shows up, right? So automatically, I think as soon as you turn 18 years of age, you should be thinking about having documents in place. But after that, and then whenever you think about it, and if you don't have them, that's the time. That's the time to draft them. But then otherwise, you would want to look at it in major life changes. You're going to look at changes in your marital status, and that's all the marital status changes, right? Marriages, divorce, separation. Sometimes people don't think about this. When they're separated, but they haven't legally divorced, you're going to want to update your documents because the laws actually do quite a bit to bolster the marital relationship and the role that the spouse has, right? It's pretty high in the priority. And so if you're separated and not legally divorced yet, you want to update your documents at that point in time. So separations, divorces, and widowhood are going to be the times of marital status that you're going to want to take a look at it. Children, changes in your children. What does that mean? When children are born, when children are born, one thing, hopefully no one ever experiences, but when children pass, that would be a time to take a look at the documents to see if it's doing what you want it to do. And has they turned 18 years of age, you're going to want to take a look at those documents. And then at that point in time, looking at the circumstances around your children, it relates to that. And that would also probably can potentially apply to grandchildren. Has grandchildren are born or great grandchildren, right? That if they're going to be included in advanced planning documents, you would want to be looking at those as the circumstances around them change. Doesn't mean they always have to change, but you will want to take into account that. Your health changes, and beneficiary health changes. Those who are going to inherit, we would want to take a look at the documents if they have health changes to take into account if what we have still works for them. And of course, our own health changes would dictate some of these document changes, and then major property changes. And that's going to be big things. I usually talk about, like, if it's not always this situation, but title document property. So if you buy a house, sell a house, um, buy a car, you're going to want to take a look at the documents at that point in time to be sure that they still reflect what you want to happen, and if any updates need to be made to that. And so those are going to be the types of things. But also, it can include not title property, right? If there is like a family inheritance that's really important in the family, then you would want to take a look at those documents and make sure they're up to date. Otherwise, every so often, every few years, if there's been no changes in marital status, children, you may just pull them out every once in a while. I have clients who pull them out once a year, take a look at them, and just be like, "Yep, still looks good," and then they put it away for another year. And but you don't want to let them just sit in there. But I've also seen clients where a will was written 10-15 years ago and they were perfectly fine. They never needed to be updated. They always met their needs. And so just because it was drafted a while ago doesn't mean it's still not a valid will and still doesn't do what it needs to be done. In all of these documents, there's going to be a person, a representative. They all have different names: agent, executor, depending on the type of document that you're looking at. But for the most part, they all serve in the kind of that same role. They are a person that you are choosing who's going to be acting on your behalf when you are not available to do so, whether it's due to your death, incapacity, or just unavailable. You're just not around. And so when you're thinking about who's going to be in that role, I mean, they're going to be acting like you. They're going to be you for legal purposes, if you kind of think of it that way. You want to be sure you're selecting someone you know and trust and who will do what's in the best interest or as you would do in making those decisions. Um, So that's kind of what you're going to want to be looking at. So this one actually can be a very, very hard step. Sometimes family member when people are drafting their own documents, the easy part is knowing who's going to get the property and things along that lines, right? But the hard part is picking who's going to be doing the role. And because I get things like, well, I love my children equally. I don't want one to think that one is, favorite, or I trust them more than the other. Um, you know, well, there's an expectation. I'm the youngest child, so I can say this, but like, like oldest child syndrome, where there's an expectation based on, um, that this is the child that is taking on the matriarchal role or patriarchal role of the family. And so they would expect to be able to take on this responsibility. Um, but they may not be the right people, right? Like they may not be the right people. It's really important to realize this is a job. I mean, it's not like well, maybe a paid job, but it's work. Like these are things that require engagement and handling things. And so when it comes to the executor and handling the estate after a person passes away, that's work that has to be done. Typically, it depends on the situation. So just keep that in mind. I'm talking generalities now, but typically that can include working with a lawyer, doing tax returns for the person who passed, and not only just one, but multiple tax returns, um, writing deeds, selling property, making repairs to property, paying debt, contacting creditors, to talk about being unable to pay the debt. That's work, right? Like that's asking somebody to take on the responsibility to do all of these tasks that need to be done. And the average amount of time can be anywhere from like 9 months a year to several years to 4 years or 5 years, depending on the complexities of an estate and what's going on in that. And and similarly with the power of attorneys, with these are things that have to kind of be done. And so you want somebody who can handle that, because remember, when we're talking about someone's passing, it's someone we love, right? Like we've just lost someone we love. We're going to be grieving. People are going to be grieving. And the person who may be the logical choice or the emotional choice may not be the best choice, right? And so it's like, well, yes, I understand that you're the eldest. I understand you're the spouse, and you're anticipating that you're going to take on this role. But I also know you and I love you and I know the relationship that we have. You're not going to be in the space to do this. I want you to do what you need to do to live in this new normal. And I want you, and so I think it's better if, Uncle Bob, who's an accountant, to handle this. Yes, he'll be grieving too, right? Like he'll be sad, but he's going to want to help you. He's going to understand the role. This is what he does for a living, or he's got the mindset to be able to do this. So we're going to ask Uncle Bob to kind of do this. He won't but he won't do anything without your understanding and things, right? So that's kind of where you kind of want to have those kinds of conversations with the people who think they're going to be chosen but are not chosen. Don't let it be a surprise to them that they're not chosen. Like, explain things to them so that way they're not surprised and they understand the decision and understand that it is a loving decision. Similarly, when it comes to picking representatives, comes to medical decisions. I always kind of say that, like, you got to pick the person who's going to make the medical decision as you would make them in that situation for yourself, right? And it doesn't mean that the person isn't going to be making a loving decision. It's just going to be a difference of opinion on what that loving decision would be. Some examples would be you're incapacitated, you're no longer able to make decisions for yourself, and an experimental treatment is available for whatever, right? An experimental treatment is available. One person might be like, no, we should go try this experimental treatment. It may really work and things along that lines, right? And that's loving. That's a loving decision. They want to do what's best for the person with these experimental treatments. But another person might be like, no, I'm looking at these side effects, the potential issues and things along that lines. It's like, that's not what mom would want. Mom would want to be able to pass peacefully. And so, and there's a cost associated with that. Insurance isn't going to cover that. And she wants us to protect the assets. And I know this, right? That's also a loving decision, right? It's loving because it's honoring what they believe to be what the wishes are. And so you're going to want to pick the person who's going to make whatever decision you would make, whether it's to go towards experimental treatment or to allow to to pass peacefully. It's going, so that is, so again, there's no right or wrong here. Like there's no statement there, right? It's what you would choose to do. And in all of that, you're going to have conversations with the person that you pick, explaining that, empower them, explain what you would do. There's no way to plan for every scenario that exists when it comes to planning. So you're going to talk as much as you can about some circumstances, some situations. Give them enough so that way they know what to do if a similar situation or comparable situation comes up, and so they can make those decisions. And again, you want to explain it to the people who are not chosen, just so that they understand why the decisions were made, because you're not around to answer the questions for them. And we want to be able to answer those questions before they come up. And then in all of that, you're also going to want to pick an alternate. So just in case the first person is unable to serve for any reason, then you have another person who can step into that role, to be able to do the work that needs to be done. Okay. So now let's talk about planning for death. I did not say this, but if anyone has any questions in the Zoom chat, please feel free to put them into the chat box. I'll answer them as I go. If you prefer to ask verbally, we can wait till the end. And anyone watching on the live stream, you can put them in the chat in the comment box. Someone will monitor that and will ask the questions at the end if they are not able to type it into the chat box while we're watching. So just be aware there will be time for questions, but if you're into Zoom, feel free to ask them in the chat box as we go. All right. So understanding property and the transfer of ownership after death. There's a lot of misconceptions around property and passing. And so I get a lot of like, I don't need a will, I don't need to do whatever, because they think that they have some misconceptions about property. And so this is my effort to dispel these myths that may exist. So the first one I usually kind of get is I don't own anything. Normally what I hear when people are telling me something like that is they're kind of saying, I don't think I own anything of value. First, that's untrue. Everyone owns personal property. You have your clothing, your furniture, your jewelry. Everyone owns personal property. I also want to say that don't underestimate the value of sentimental property. People put a lot of emotion into items that belong to people they love because they identify that person with that piece of property. Grandpa's favorite sweater or mom's favorite coffee mug that she always used. There is actually, and while it may not have a high dollar value, in the sense of like on a retail secondhand market, to that individual who loves you, who looks at that and thinks of it as, it's invaluable, it's priceless, right? So so don't assume that just because it may not have a dollar associated with it, it doesn't mean that there isn't value to it. But everyone owns personal property, and we still have to figure out what to do with that. If you're renting, someone has to be able to access that apartment and do what they need to do with the furniture, with the clothing, what happens to it, right? Someone needs to be empowered with that responsibility. And so that's kind of the first one. And which leads me into the second one. Someone must have the authority to do something with it, right? Like there's a lot of, well, sure, we know what the law says on who's going to take care of the property, right? Because I think that misconception. It's like, well, the law will take care of it, right? There's safety nets within the law, so to some degree. And but who's going to be responsible for that? So you have a house and it's going to get sold, right? We know the house is going to get sold, so I get that. It's like, oh, the kids are just going to sell the house. Okay, who's going to decide to hire a realtor, not hire a realtor? Who's going to decide if the house gets repaired and what repairs get done, what the budget is going to be for those repairs, for it, and then who's going to do the final accepting of the price, right? Like who's going to be responsible for that? So this idea is like, oh well, they're just going to sell the house, okay. Well, but someone still has to kind of take care of that. Who's going to be responsible for that? One of the things and one of the advantages of, and why I highly recommend everyone always have advanced planning, is that you're trying to avoid conflicts, right? Like people fight when people pass away. And so it's part of a grieving process. People are grieving, and so they kind of take out anger and space and frustration, and so people will fight. And I wish I can tell you that there isn't that people don't fight over property and over things. They do. And so if we're trying to avoid the conflict, you're going to empower a person to be responsible for making those decisions. And, you know, and usually if you have picked well, the person who's going to be in charge is not going to do it in a vacuum, right? They're going to be like, well, I'm empowered to do that, but they're going to let people know what's going on and take care of the things according to the instructions that you have given, because you have talked to them about what you want and what you want them to accomplish by giving them that power and the authority to represent you when you are not available to do so. And so that's kind of the other thing that people need to be aware of. Titled property. Again, remember I talked about, like, we need to look at our documents when we get titled property. It typically has to go through some type of a legal process to show who the new owner is, right? So in order to know who owns a house, we go look at the property records at our clerk's office, and we do a search and we find the deeds and we know who owns the property. Well, when someone passes away, we need new documents to show who the new person is, who are the new owners. And so we have to go through some kind of a process. And there's different ways that that can happen, which we're going to talk about in some of these documents, which is that can happen in a transfer on death deed. It can be part of the probate process. And so there's multiple ways that it can happen, but we need to have this document in place. Similarly with a car, because a car is titled, we got to do something. And again, multiple different ways that that can happen. There's declaration of beneficiary. Again, we're going to talk about all these documents later, so don't freak out. There's a form that you complete after death with DMV probate process. So it's like, so we have to do something with that to ensure that we don't get what is called a cloudy title, where we're not sure who owns the property. And a cloudy title can have massive impact on the value of the home. And so we have built equity in our homes, we have built equity in our property. We want to, when we are handing to our next generation the wealth that we have accumulated in our lifetime, we want to preserve as much of it as we can. And one of the best ways and for a lot of people, the biggest source of wealth is the equity, the value that they hold in their real property, their houses. And so we don't want to lose any of that value just because of a cloudy title. Okay. Another thing is that verbal agreements are not enforceable in the state of Texas. I hear we have an agreement. Fantastic. Put it into writing, right? Like, and so because when they're not enforceable, no one can go to court and say, well, we agreed that Joe was going to get the house. Well, great, Joe, but how do we know that that's true? You could be coming in and saying, that I get the house because Susie said I was getting the house, but we don't know that. There's nothing in there. So put it into writing. Also, sometimes people misunderstand. There's a misunderstanding between the individuals. Someone may walk away from the exact same conversation thinking that Joe's going to get the property, but the other person walking away from the exact same conversation believes that's like, oh, well, Sally's going to be able to live in the house, and then Joe's going to get the property when Sally passes away down the line, right? And so completely different opinions of what come out of it. So I always say, put it into writing, make it clear so that way there's no questions, and then it remains enforceable. And what will happen afterwards becomes an enforceable agreement, as opposed to just I don't, an unenforceable one. And then the last misconception that we get that I have to dispel is that a co-owner of a property does not automatically get the property when the other co-owner dies. That's called a right of survivorship. We are going to talk about that in more detail in a couple of slides, but that's not automatically true. It depends on the family dynamics, what's happening there, the type of property that we're talking about. Are we talking about community property versus separate property? Are we married? And do we have children from a previous relationship? If there's no children, are there any children? So a lot of that impacts on whether or not the co-owner inherits the property. And so a lot of people believe that the spouse automatically gets it. And that's not always 100% true, because again, it depends on the dynamics of the family. And so you want to always be kind of checking on that, because what may happen may not be what is anticipated, may not be the case. All right. So let's start talking about some documents. So the first one is a will. Most people do know what a will is. It's a legal document in which a person called a testator writes down what they want to happen to their property and debt, called collectively the estate, after their death, and who they want to manage that estate. And that person is known as the executor. That's the representative. Um, And that's essentially what it is. One takeaway from this, I want everyone to walk away with, is that everyone needs a will. Like, it doesn't matter about any other documents that we put into place afterwards, because I'm going to talk about some other things to avoid that can bypass and avoid the probate process. But everyone needs a will. And because it's better to have a will and not need it than to need a will and not have it. Because it dictates what happens in the court process. If you have a property well executed, you have a well drafted, properly executed will, the probate process is actually pretty straightforward. It can be pretty easy in the state of Texas. And um, it's not short, like it does take time, but it can be relatively easy. And the but if you don't have a will, or it's not properly drafted, or it's not properly executed, that is where the probate process can get complicated, can get expensive. And I'm going to talk about that in my next slide in a minute, to kind of really put a pin into the understanding of why everyone needs a will. But I want everyone to walk away with that, because if you end up not having a will, again, that process can be really difficult. It can take years, and it can be very expensive. And again, I'm here to save you money. You worked your money, you wanted to go, your assets, you wanted to go on to the next generation. And so having a good will does that. Now, a will only covers a probate asset. So remember, I talked about the after part is probate, is when a person passes away, is the court process called probate. And so a will only covers that. And the easiest way to talk about that is to kind of talk about it in the negative. So is to kind of talk about what is a non-probate asset, what is not covered by the will typically. And so for most of us, that falls into four types of categories. So this is property that our folks in Austin, so this is Texas state law, our folks in Austin have kind of defined that the ownership is it's owned in such a way that the property automatically passes to another person without having to go through the probate process. It's just the nature of how this property is owned. And so again, four different categories. Retirement accounts is the first one. IRAs, 401ks, 403bs, whatever retirement account that you have. You're going to designate a beneficiary. You're going to contact the financial institution where those accounts are held. You're going to complete a form that names who the beneficiaries are going to be and what allocations that they are going to have. Life insurance proceeds. That is also a designated beneficiary. Whoever the policyholder is, you're going to contact them. You're going to complete your form identifying who the beneficiaries are, and that. And the third type of thing is out of the four, or third out of four, is a payable on death account. So those are going to be our checking accounts, our savings accounts at our financial institutions, our banks, credit unions, those types of accounts where you're going to say, I would like to be a payable on death account. Those are not co-owners of the property. They are not on the checking account. They can't write a check. They can't withdraw money from that account. But what it is that they're named as the beneficiary of the account upon the passing of a person. And so on all three of these, what will happen when a person passes away, the retirement accounts, life insurance proceeds, and payable on death accounts, is those financial institutions will ask you to complete a form, whatever their documentation requirements are, and then probably submit a certified copy of a death certificate, and then they will disperse the funds according to their own processes and procedures. All of that without having to go through a probate court. Okay. And so now I'm going to talk a little bit about like why it's important to have a will. I'm going to use the example of a life insurance process. And so bear with me. We're going to talk about the probate process right now for a little bit. Okay. So, um, so you have your life insurance proceeds and you designate a beneficiary. Um, Submit your death certificate, etc. Now, what happens if you don't name a beneficiary on your life insurance policy? They don't just decide. They don't get to just decide who gets the property. Almost in the majority of these cases, the same will be going for banks, and the financial institutions where retirement accounts are. They're going to require someone to declare who the owner of the property is going to be, and they're going to want it to be a court. It's very rare for an institution to not require a judgment, a court decision on who the heirs are going to be. And that's where the will is going to come into effect. And so you've gone to the life insurance policy and they said, so sorry, there's no beneficiary listed on the account. We're going to have to pay the benefits of this account to to the estate. So let's assume that the life insurance policy is $20,000. And so now we're going to the court. And so now we have to go to the court. But good news is that we have a well-drafted, executed, properly executed will that says that the residuary of our estate is going to be divided equally between Bob and Sally. And so now, so we didn't know we needed to go to court. We didn't know we needed a probate proceedings, but now we're going to go to court. We have a will that says that, and the executor is going to go hire an attorney. The attorney is going to charge $1,000 to do the probate. I don't know if that's how much attorneys go for nowadays. So don't come back. Jesse, you said $1,000. It's an example. And so they've gone to court. They spent $1,000 on the attorney. Judge has determined that the will says that the $50,000 or the $20,000 is supposed to be split equally between Bob and Susie, or Sally. I think it's Sally, Bob and Sally. And so now we go from $20,000 to $19,000. Each of them are going to get the 8,500. I think I did the math right. 9,500. It's split equally between them. Okay, so that's what would happen. Now, what would happen if the beneficiary was listed? It was Bob and Sally. On the full 20,000, they would get the $10,000 each to divide it equally between them if the beneficiaries had been listed. What happens if there's no will? So this is where I put the pin. This is why you need a will. Better have a will and not need it than to need a will and not have it. Now we have the $20,000 that has to get paid into the estate, and now there's no will. So we don't know. Now the court has to decide who are the heirs at law. What does the law say are the heirs? Now, so questions that we have to ask. Was the person who passed married? Right? And if they are Bob and Sally's the spouse's children? Maybe, maybe not. Right? And so depending on what that is, so if we assume they're not, spouse on personal property, may be entitled to the full amount. It may be split between them. It's typically split between 50% to the spouse and half to the children. But here's the other question. Are we sure that the person who passed doesn't have any other children? So while we have an attorney who's like, well, when you had a will, I was going to charge you $1,000, but since there's no will and it's going to take more time, more work to get us to do that, I'm going to charge you $2,500 for my services. So now we've gone to $2,500. That $20,000 is automatically now down to $17,500, right? So we've already reduced it to $17,500, and we're not sure who's going to get the property. Now we have a court that says, hey, but we don't know. We don't know for sure. There's no other children. So I now need the estate, because the estate is the person in court, to hire somebody to go find out to be sure there isn't any other children. It's an attorney ad litem representing the unknown heirs. That's what the court may require. That attorney has to get paid by the estate. And that attorney might be like, yeah, I'm going to charge you $2,500 for this, for me to go do this work, to go make sure there's no other children and things on that lines. So now that $20,000 has been reduced to $15,000, and then it gets split in half for Bob and Susie, assuming that I keep changing Susie. We're going to assume that her middle name is Sally. Susie, Sally are going to, has been reduced significantly by that $5,000. And so those are just kind of the examples to kind of take into account when you're thinking about that, on why it's important to have a will. Now you're like, Jesse, I think I know what I own. Believe it or not, it does happen more often than you think. Where people will end up with inheritances that they weren't expecting to have, or with property that they didn't know existed. Their life insurance policies. Sometimes employers have life insurance policies for their employees, and the employee may not realize that that policy existed. Some credit card companies put a life insurance policy, give you a gift one. Like, did they just have a gift policy as a credit card owner, of an account? Then like $1,000 policy or a $500 policy, and so you have that. I don't know. I would want that $1,000. And so it's so there's those types of things. Inheritances. Sometimes what happens is that you don't know, right? And so when we talk about clearing title and clearing property and things along that lines, sometimes the person who's going to inherit the property is a cousin, right? And or an aunt, and now that person has passed, but the property is going to them. So who's going to inherit the property? So sometimes inheritances can come into play that we weren't aware that was going to happen, and now we need to determine who's going to be getting the property. So it actually happens not as infrequently as you think it would, where all of a sudden a person passes and we identify property that we didn't know existed. And sometimes it happens years later. There's unclaimed property. If you don't check that website, sometimes an unclaimed property pops up, and a few years later, and you're like, wait, that's my parent, that's my sibling that has that money. And now and the state won't issue the unclaimed property except to the properly named heirs or executor of the estate. And so just saying, it does happen. So have a will. Um, the last type of non-probate property, and I did intentionally do it differently because the first three, retirement accounts, life insurance proceeds, payable on death accounts, those are beneficiaries. Oh, I just realized. And so you're naming a beneficiary. I do want to say this. The biggest thing that takes people to probate court when they are planning that they don't realize is their bank accounts, is their checking accounts. And so you want to be sure that if we're trying to avoid the probate process, again, probate's not a bad thing if you need to go through it, but if you can't avoid it because you don't need to, why go through it? And so, and I'm going to talk about ways to avoid the probate process for cars and property in the next slide. But when it comes to our checking accounts, our savings accounts, there's two ways that you can do that. One of them is the payable on death account. And that, again, you own the account. It's a beneficiary who receives the account. The fourth type of non-probate ownership is the joint tenancy with a right of survivorship. So when I talked about that misunderstanding where the owner of the property automatically, the survivor gets the property, this is what we're talking about. This is not the default in the state of Texas. The default is joint tenancy. So we own an undivided interest in our property, but it doesn't mean that the survivor of the property automatically gets it. The property passes according to our will or according to the heirs at law if we don't have a will. And so that may or may not be the co-owner of the property. We just don't know. Family dynamics, individual plan. But you can create a joint tenancy with a right of survivorship, which is an agreement between the two individuals that upon the death of one, the survivor, the other owner, is the one who takes the property, who now owns the property 100%, instead of it passing according to the will or the heirs at law if there is no will. So that is what a joint tenancy does. You are co-owners of the property. You can also do this for your bank accounts, your real property, your cars, and things along that line. So you can create that. But it is a creation. You are due because it's not the default. The default said joint tenancy, which is that we share ownership, but our half goes according to our will or theirs at law. Now you're going to create, because that's a default. That's what normally happens. Now we're going to create a joint tenancy with a right of survivorship. So I always recommend that if you're going to do that for your real property and your cars, that you really talk to somebody about it before you do that. There can be some unintended consequences, not seeing around corners, and so you want to be sure that before you do that, you can't. It's very difficult to undo that, and once it's done, and so we do normally recommend that you talk to somebody because you can probably get the same result in a will or transfer on death deed, which we're going to talk about in a minute. And so, and that might be the better way to move forward to ensure some protections that you don't get when it's a joint tenancy with a right of survivorship, because you can't change the joint tenancy. But for your bank accounts and your savings accounts, checking and savings accounts, this is something that you can do as well at the bank, and you can, or financial institution, you can say, if you don't have the payable on death account, then you have a joint tenancy with the right of survivorship. Now they are co-owners, right? So you both own the property, you both have 100% access to the property, but it doesn't require a court to come in and make a decision on who gets the property. So just be sure that you kind of do that. It is the biggest thing that normally drives people to have to go to probate court, is that they haven't planned for their financial accounts to be able to be accessible to the family members or to the heirs afterwards. And so that is something to keep in mind when you're planning. So I've referred to the transfer on death documents a couple of times, and here we are. So non-probate assets are property that the way that they're defined as property that doesn't pass through the probate court process unless there's no beneficiary listed, or there isn't a survivor. That's the only time that it would go into the probate court process. But houses, land, cars, RVs, etc., those are probate assets. They would typically be handled through the probate process. Whoever is going to be the heir based on the will or the heirs at law, if there is no will, that would typically go to the court. The court will make a determination on who owns that process. So they are still probate assets. However, the state legislature in Austin, they have passed laws that allow us to pre-plan, to be able to plan for a way to pass these property without having to go through the probate process. And so the first one is a transfer on death deed. It is a deed. This is passing real property, land, houses. And just like when you buy a house, you get a warranty deed, or when you gift the house, you get a gift deed or a quitclaim deed, right? It's a deed. So you're going to, oh, okay. So you're going to get a deed and you're going to file it at the county clerk's office where the property is located. And this one does require it to be filed to be effective. Um, and then when the person passes away, the death is registered. There's some kind of registration of the death. And then the title has passed to according to the terms of the transfer on death deed, avoiding the probate process. Same thing with vehicles. Now, vehicles include RVs, cars, as well as mobile homes. And that is going to be a beneficiary designation of a motor vehicle. And so those are a form that you would file. It gets filed with the tax assessor collector's office. Those are the offices that handle title registrations to vehicles. And so that form will get submitted there, and very similarly a registration of the death happens, and then you have the new title, and that shows who owns the car, RV, and or mobile home. um, in Now when we talk about like whether or not you should do this, again, individual plans, you should kind of be considering things along that lines. There is a cost associated with both of these. For the real property, you're filing a record. It does depend on the cost in different counties at different rates. In Harris County, we're looking typically between $25 to $35 to file a transfer on death deed. For the vehicle, for the beneficiary motor vehicle, it actually is around $125 to be able to do that. So there's a cost associated with it. And so that might, that might impact your decision making on whether or not you want to do it now versus putting it into the will or later on. So just kind of keep that in mind. I usually recommend for the vehicles that one's a little bit iffy for me. I don't always recommend a beneficiary designation for a car. If it's not going to be your last car, right? So I just bought a car about a year ago. We love it. We're probably planning on driving it for 10 years, but I don't anticipate it being our last car. So we didn't do a beneficiary designation for that. And that's my decision. That's what I decided to do. Another person may feel differently about that. Some people have antique cars, and that they plan on passing on to somebody else, and so then yeah, you would probably want to do it for that. But I do recommend it for RVs and mobile homes. That's the two that I would recommend, because people own those properties long term, and they are basically residences, and people who have RVs, who are traveling around the country living in their RVs, living the dream, as they say. You're going to want to do that. Those, because that's effectively a residence. Same thing with a mobile home. And so that is so just kind of keep that in mind when you're trying to decide on whether or not you want to use it or not use it. That's usually what I kind of recommend. Last vehicle, go ahead and do it if you want to do it. Definitely do it for the ones that are owned a long time. So what is the impact of this as it relates to you own your property? It's still your property. You can do whatever you want with it. You can sell it. You can mortgage it. You can gift it away. It's still yours. So you can do everything. And as you see the question, and yes, you can change your mind. You can change your mind on who gets the property. Now, this is something that's really important to know, though, that when it comes to doing that, you need to change it. Like, you need to do a completely new document, submit a new document. You need to revoke the other one, and in general. So yes, so you can change the beneficiaries on these documents. You just complete a new one. file a new one, and that one will take precedence over it. So this is not a forever thing. You can change your mind about it. But the key thing that you have to remember is that these documents, the transfer on death documents, the deed and motor vehicle domestic beneficiary, take priority over the will. 100%, because it's never going to go into probate court. Remember, a will only applies to probate assets, and so it only goes into probate court. If you have a transfer on death document for your car or your property, that's never going to go to probate court because it's passed outside of the probate system. It's not going to be covered by the will. So these take priority over the will. So if you change your mind about the beneficiaries, you can't change it in a will. So if you write a will giving that house to Bob, and then you do a transfer on death deed afterwards giving it to Susie, Susie gets the house. If you do a transfer on death deed giving the house to Susie, and then you write a will giving the house to Bob, Susie gets the house. It doesn't matter what order and timeline or anything along that lines. The transfer on death deed is going to control over the will. And so be sure that if you do that, that you and you wanted to pass according to the will as opposed to the transfer on death deed, then you need to revoke the transfer on death deed. Okay. Now, I want to say that transfer beware. It's not ideal in all situations. In my part 2 session, I do talk about how to complete a transfer on death deed on your own, and I do talk there in a little bit more detail about kind of the situations where you're not going to want to do it. But but in general, it's not ideal in every situation. Again, are we trying to avoid conflicts? Because sometimes you don't want to have multiple people inheriting the property, and because if if you're going to plan on selling the house and 3 people are going to inherit the property, um, again, who's in charge? Who's going to be dealing with what? Yeah, we're avoiding the probate process, but are we still going to have a conflict that's going to be happening there? It may be easier to put it into the probate process with a well drafted, properly executed will that makes it seamless. So because now we have a person who's going to be in charge, who's going to be making those decisions. And so I always kind of say keep that in mind. Like, what if there's a disagreement on who's going to, what if one person who's inheriting the property wants to live in it but the other 2 want to sell it? How is that going to get resolved? And so just kind of keep that in mind. I always kind of say we have to be sure that we're thinking about not just us, what makes it easy for us to transfer the property according to the rules that we want to be able to do, but we have to be thinking about the impact of the people inheriting the property and whether or not the document that we have used is going to create the situation that makes it easier for them to inherit the property without any conflicts or expense. And so we kind of have to balance that out. You also don't want to use a transfer on death document when there's instructions. And so, for example, when I talked about like that, my example of like the verbal agreements where Bob walks away thinking, or Joe walks away thinking he's going to own the house, but really Sally is going to have a life estate. Those are instructions, right? We want Sally to be able to live in the house for as long as she wants to live in the house. And, because she's raising kids, they're going to school, and they've been living with mom, taking care of mom. And so we want Sally to be able to live there as long as she wants. And then afterwards, it gets divided between Bob and Sally. Well, those are instructions. You're going to want to put that into a will for that will to be effective. You cannot do that in a transfer on death document. Those types of instructions cannot go into that. Similarly, other types of instructions. It's not uncommon to have a person to say that they want a certain amount of proceeds. Like, I've definitely seen it where clients are like, yeah, I want the house to get sold and I want, it to be divided equally among the kids. But Sally paid for my roof a year ago. And I really think that she needs to get some of that money back beforehand, right? It's unfair that she took money out of her savings to pay for my roof. So I think she should get the first $20,000 out of the proceeds because that's how much my roof costs. I don't know how much roofs cost, but that's how much my roof costs. So I want her to get her money back. And then the proceeds get split evenly among the children after that. Those are instructions. Again, you're probably going to want to put that into a will as opposed to putting that, relying on the verbal instructions that you would have to do for a transfer on death deed. I saw a question. I want to make sure I answer that. Oh, I'm going to answer that question in a minute. Miss Brooks, I'm going to answer that in a second. All right. Okay. So next up, we're going to talk about Trust. I get a lot of questions about trust, and I always say this one is hard. So, what is a trust? A trust is an arrangement where one person or entity called a trustee holds legal title to property for another person, and they're called the beneficiary. Many different types of trusts: living, revocable, irrevocable. There's special needs trusts. There's all sorts of different types of trusts. You should discuss this with an attorney. Generally, what happens when I get asked this question is because you may have watched a national expert. You've watched Good Morning America or CNBC, and some national financial expert has come on and said, everyone needs a trust. This is what no one wants to go through the probate process. You need a trust. Now, here's the thing. Maybe. I don't think trusts are necessary for everybody. In the state of Texas, remember, we are talking about Texas and property owned in Texas and how it gets passed in Texas. Our probate process is actually pretty straightforward. If you have a well-drafted, properly executed will, it can be pretty seamless in general. So when people say, well, I'm trying to avoid the probate process because it's hard, it's difficult, and this is what the national expert has said. Well, in some states, it is. Some states, the probate process is lengthy and complicated and can take years. Very famously, Elvis Presley's estate is still open in Tennessee. There's a battle going on for some from other, and I think Prince's will is under a contest right now. So it's like, so yes, in other states, the probate process can be very complicated, can be very expensive, and takes a really long time to get through. But those are those state laws. Now, I can't speak on the other states. I practice here in Texas, but those are those other states. I know what happens here in Texas. And so to me, the question is, when we're talking about a trust, what is the goal? What are we trying to do? Because when we're talking about a trust, we're talking about or versus a will, we're talking about, like, again, those individual needs. Why do we need a trust? And I don't think that avoiding probate is a good enough reason on its own. It may be a reason, it may be a factor in choosing to go via a trust versus a will. But I don't think it's the only factor, and it should not be the guiding factor. We should be looking at the individual needs and what is the goal that we are trying to affect? What are we trying to do with our trust? And that's why I think it's really important to talk about it with an attorney. The work associated is not any less, by the way. Right? When I talked about, remember, the probate process, the work that an executor has to do, drafting deeds, talking to attorney, paying creditors, paying the bills, doing all of that work still gets done for a trust. Like, that still has to happen. A trust document doesn't automatically remove that work. That work still has to happen either way. And the cost of creating a trust, depending on that type of trust, may be more expensive than the cost of the probate would have been, again, with that well drafted, properly executed will. And so I think that, like, those misconceptions about, like, well, trust is going to save me money, it's going to save time, it's going to make it easier for my heirs, things along that lines, not necessarily. It does, again, it depends. The work still has to be done. Who's doing it? Maybe it's you, maybe it's someone else, maybe it's the trustee. But it's so I recommend that you talk to an attorney about that. But there are needs for it. There are needs for trust, and I don't want to dispel that. So one of the things I talked about at the beginning, it's like, who's inheriting the property. I mentioned a person living with disabilities. If you are a person who is inheriting, if the person inheriting the property is living with disabilities, and due to their disabilities they are unable to work, and they receive government benefits due to lack of income or being low income, an inheritance may impact those benefits. And so, and they may lose those benefits because of the inheritance. Again, it depends on the nature of the inheritance, what's happening, very individualized, which is why I say talk to an attorney. But we want to protect those benefits, right? Because the inheritance is probably not enough to replace the cost of living expenses that they would lose by losing the benefits. And so we would want to look into what is known as a special needs trust. And so trust can be needed, but remember, here the distinction that I'm making there. What is the goal? The goal is to protect the benefits of the person living with a disability, and to ensure that they are able to care for the property and retain the benefits they're receiving while also getting the benefit of the inheritance. So just kind of keep that in mind. Okay. All right. So, getting to the question around debt, and whether or not you can do things. So, debt survives. Unfortunately, I wish we can say that it doesn't. There's a misconception around debt and when people pass away. So let's talk about first. There's different types of debt. Debt, it has different categories. Two, basically, unsecured debt and secured debt. For our purposes today, it may get a little bit more complicated, but for our purposes, we're going to talk about unsecured debt and secured debt. Unsecured debt's the easy one. It's the easier one. We're talking about credit card debt, medical debt, that type of thing. Unsecured means that it was secured by the promise of the payment, that the person has good credit, the income is the amount that they have, and the expectation that they're going to be able to pay the amount back. That's usually the credit card debt, right? Medical debt, that's different. That's, again, probably whatever the insurance company is and the expectation that you're going to take on the responsibility for the amounts that's not being paid. So those are unsecured debt. They cannot necessarily, well, I shouldn't say this. Generally, they're not coming and seizing property to pay off the debt. I mean, there's things that can happen, but for our purposes, that's what we're going to assume. Some, not all, some creditors will discharge the debt and not expect the estate to pay. But if the estate is solvent and the estate has the ability to pay that debt, the expectation is that the estate will pay it. And so not all creditors will discharge a debt at death, an unsecured debt. And so that debt might still have to get paid. So it does survive. And again, that's typically work done by the executor to determine how much money the estate has to pay it, and then determine the amount that needs to get paid. And if the estate's insolvent, to request a discharge of the debt. That doesn't actually mean that that's done, that there's not more work to be done with that, because the credit card companies can still issue cancellation of debt income to the estate. And then in which case now the executor is going to have to deal with IRS tax income for cancellation of debt income to the estate. So it can get pretty complicated. Again, it's one of those things that the executor is going to have to work through. But again, some will just discharge debt and won't issue cancellation of debt income. So that's kind of a misconception that people have around unsecured debt, that it automatically goes away. It does not. Now, secured debt is houses and car loans. That's basically it. We're talking about mortgages and car loans as what we're talking about. The people who inherit that property subject to that debt. And so let's talk about what that means. So, right, we're talking about mortgages and reverse mortgages. So to answer the question that got asked, yes, you can use a transfer on death deed or a will for a property that has a mortgage on it. You can definitely do that. No worries. Either way, Todd or Will, you can pass your property on with the mortgage. Now, you may need to think about how are they going to pay that mortgage, because they are inheriting it subject to that. And so on a standard mortgage, your 15-year fixed or whatever, right? The financial company will typically work with the executor and the heirs to give them time um to come up with financing or to pay off the debt, right? And so just kind of like they're going to be able to take time for that, but they have to do that. They're going to have to continue to pay the mortgage. So going a callback, remember, people need to have access to the bank accounts. If you want the executor to continue to pay the mortgage while they're processing the will and going through the probate process, or the heir is going to be living in the home, maybe you want them to be the beneficiary of your payable on death account for your checking account, so that way they automatically get the money to be able to, that's in the bank account, to help them pay for the mortgage. Maybe you want them to be the beneficiary of the life estate, of the life insurance, and be like, hey, I know there's a mortgage on the property, so I'm going to make you the beneficiary of my life estate, and my expectation and why I'm doing this is so that way you take that $20,000 and pay off the $15,000 mortgage remaining on the house. Right? So that might be some planning. That's planning, right? Different ways to solve a problem in anticipation of a potential problem coming down the line. And so, but typically this typical mortgage company will work with the executor and the heir to give them time. It's not indefinite. You can't do it forever. But as long as that mortgage is getting paid, they'll be like, okay, you need to refinance, or they'll coordinate for whoever the beneficiary is to take over the loan. Again, depends on the financial institution. I can't tell you for sure what they would do. But that's the mortgage. The second type of thing that we have to be worried about when we're talking about debt on a property is a reverse mortgage. This one is a little bit not more important, but can be detrimental to an heir. Reverse mortgages are due 6 months after the date of death. So, person passes away, calculate 6 months from that date. That is when the reverse mortgage is due. That's not a lot of time, by the way. 6 months is not a lot of time. Keep in mind, a person has passed. Funeral arrangements need to be made, depending on how long that takes. We have the grieving process. The average amount of time currently to start the probate process in the state of Texas is 3 to 4 months after a person's um, passing. That's the average amount of time when probates get started currently. And so when you have 6 months, that only gives you about 3 or 4 months to do what needs to be done to be able to pay off that reverse mortgage. And so that's something to kind of keep in mind. You need to be sure that whoever's inheriting the property is aware that there's a reverse mortgage on the property and that they're going to have 6 months to pay for it. And that means they're either going to have to sell it if they're planning on selling the house, or securing new financing, or maybe the life insurance policy. Again, part of that planning. How are they going to pay for that? But the takeaway from that, it's like, or maybe we need to consider doing a transfer on debt deed for that property to allow them more time to sell the property. They're going to be selling the property because now they're going to own it or get new financing, as opposed to doing it in a will, right? Because remember, individual plan. We got to be thinking about our individual needs, what is happening with the property, who's inheriting it, and what needs to be done. And so you're going to want to look at some different options there. But what would the beneficiary and the executor need to know, because the two of them need to know together, right, is that there's a reverse mortgage and it has to get paid in 6 months. And very rarely these reverse mortgages negotiate for more time. They may give you some, maybe, depending on who they are. Some, but I don't want to promise that, because a lot of them don't, because the terms say 6 months. So just kind of keep that in mind when it comes to the debt. Okay. The last thing when it comes to preparing for death is a disposition of remains. This is just a legal document that names an agent to make decisions with respects to disposition of remains. Funeral arrangements is basically who is going to be responsible for doing that. That can be include instructions on funeral instructions, prepaid arrangements, burial versus cremation instructions. It just helps resolve conflict before it arises. But it's a pretty standard document. All right. I do see this other question that was directed to me. I'll answer that at the very end. Okay. All right. So next up, we are now going to move to caring for ourselves in the event that we are unable to do so. And that's planning for incapacity. That's really the majority of it is planning for our own incapacity. We are still alive, but we've had a cognitive decline and we are no longer able to make decisions or care for ourselves. And so who are we going to put responsible for that care for us, and the documents that we need to have in place for that? So the first document that we're going to kind of talk about is the in-between document. This is called a supported decision-making agreement. It is a document signed by an adult that requests a supporter to help with decision-making. The adult, the person signing the document, is still able to make decisions for themselves. They're able to, and they want that, but they recognize that there is either a cognitive decline that's occurring, or there's maybe some mild incapacity, but they're not fully incapacitated. And so they need help making decisions, right? So, and it's like, they're not making, like the supporter, the person coming in helping, is not making the decisions. They're just there to be like, are you sure that's what you would like to do? And things along that lines. The supporter does owe a fiduciary duty, which means that they are doing what's in the best interest of the other person, not what they would do in that situation, but what is in the best interest of that. And it's a legal obligation. It is a less restrictive than a guardianship, and it's a good in between to kind of help people who have that diminishing or a cognitive decline that's happening. It is something that we do kind of potentially to think about for an aging population, an elderly population. And fortunately, for some of us, as we get older, we do get a bit of a cognitive decline. The studies have just indicated that at some point in time, as a general rule, not everybody, but as a general rule, it becomes harder to identify scams. And these scams are getting good, like, right? Like, I'm pretty good at identifying, and that I miss one. Not that I got scammed, but it was like, you get those test things, like they send out those tests, and I was like, how did I miss it? was one thing. There was one thing in the email that you were just like, oh man, but they're good. Like these scams are good. They know how to say it, and they know how to kind of do it. And it becomes harder to identify those for some people, especially at the age. And so this might be something that's worth to put into place. Give with your bank, hand it over to the bank. So that way, if all of a sudden you're coming in and being like, I really would like to transfer $5,000 to a person outside of this country that I've never met in real life, that the bank knows to call your supporter so that the supporter can come in and do some research, do some support, and make sure that $5,000 does not get sent to somebody that you don't know, that may be lying to you, that may be just trying to take your money and not really in the best interests for you. But just something to consider to do. It's very useful for those of us as we age. It's also very useful for children who are living with disabilities, who as they age into adulthood, as they turn 18 years old, who have who maybe again that diminished capacity, are able to live on their own, able to do things for themselves, but they may need a little bit of support in some decisions. Okay. A statutory durable power of attorney is a person who makes legal and financial decisions when a person is unable to do so. Pretty much at this point in time, we now split into two different categories. We split into financial legal matters on one side, and we go into medical on the other. So when we're kind of planning for that. And so this is the financial and legal side. So this is things like making car payments, paying loans, making sure rent gets paid, paying child support if child support's owed, handling a business if there's a business. That's what we're talking about when we're talking about a statutory durable power of attorney. So what does all of this mean, right? Statutory means we don't have to think about it. The folks in Austin have already written it. They've written what the form looks like, what it's supposed to say. And when at the end of this presentation, you're going to get templates. You're going to get a template for a statutory durable power attorney. It's going to be exactly what's written in the laws, in our code books, and you don't have to think about it. The only thing you have to think about is what powers you're going to give to the agent that you name, the person that's going to serve in that role, and when do you want it to be effective. And so that's what you're going to be looking at. So that's what makes it a statutory. Durable means it survives the incapacity. So when you're no longer able to make decisions, you're no longer able to revoke the document due to incapacity, then it survives that. It will continue to be effective. So that's why it's an advanced planning document. Um, the powers in there are pretty broad in general. You kind of have to look at each of those to decide for yourself on what powers you want to give. Some powers are broad. Some of them require specific permissions to allow that person to do that when you are not able to do that any further. Any questions around what that document is and what those properties are, I recommend you speak to an attorney, because again, we would want to know your individual situation to be able to kind of effectively advise on whether or not any of those powers should or should not be granted to your agent. Then you can choose when it's going to be effective. You can choose it to be effective immediately, which is the default. So as soon as you execute that document, and it's notarized, you give a copy to your person. That person go across the street and go to the bank with that document and do what they need to do with your banking account at that point in time. So it can be effective immediately, or it can be effective at the springing. It's springing, which means only at the time of incapacity. Incapacity is determined by an examination with a doctor. Doctor does an examination, determines you're no longer able to make decisions on your own, and then that is when it's going to be effective. And so one of the things about this that's useful is that while we are planning for incapacity, it actually can be very useful as a support document. So again, that supported decision-making document that I just talked about right before this, the person who's the supporter doesn't get to make decisions. They're just there to help, right? But when it comes to a statutory durable power of attorney, maybe you have people who are already helping you, who are doing things for you, and by making it effective immediately, they can now actually do things, right? So with the supported decision-making document, you need some help. You go to the bank and you're like, no, I need some help. So now you call in the supporter gives you instructions and gives you information and things like that. And then they're able to then you make the decision at the bank itself, right? With the effective immediately statutory power of attorney, that person can go do it on your behalf, right? You can say, hey, I really need you to go do this thing at the bank, and you could go do that. So a lot of people, as they age, I'll tell you, for right now, in my personal situation, I have an effective immediately power of attorney with my mom because she doesn't like talking to the bank on the phone. So, she's fine going to the bank in person, but if they tell her that she needs to call and do it over the phone, I get to be the lucky one to do that for her because she just doesn't like talking on the phone. And so, but I have a power of attorney that lets me do that. And so, and I do some other things too that just makes her life a little bit easier. And so just kind of think about that. Again, individual need, do what's right for you and your family. But there's no right or wrong here, is basically what I'm saying. There's pros and cons to doing it both ways. Now, again, we're kind of split into the medical side of things. A medical power of attorney is when a person is no longer able to make medical decisions for themselves. It is effective only at a time of incapacity determined by a doctor. Obviously, as long as you have capacity and you're able to articulate your wishes, you are always going to be in charge of your own medical care and your own medical decision making. So this is very effective to have. And so this is where I take a few minutes to talk about what I think are the 4 minimum things that you need to be protected in estate planning. We're going to talk about more documents. We talk about a lot of other documents in preparing for planning for death, but there are 4 things that everyone needs to be minimally protected. Everyone needs a will, no matter what, right? I hope I put that into you. Everyone needs a will. Do something with your bank accounts. Make sure they're either a payable on death account or a joint tenancy with a right of survivorship or some other type of co-ownership that allows a person who needs to be able to get access to those funds in the event that they need to get access to them, they have it, right? So you're going to want to do something with your bank accounts. Everyone needs a statutory durable power of attorney, and everyone needs a medical power of attorney. Those are the 4 things you need to have to be minimally protected. Everything after this is going, or every other thing that we talked about is nice to have, good to have, recommended if it works for you and you need it and you should have it. But if you walk away being like, I need to try to draft documents on my own, Jesse, what should I have? I don't have time to do 8 documents right now. Those are the 4 things that you need to go and work on. Okay. So now when we're talking about those power of attorneys, the medical one and the statutory durable power of attorney, we're talking about incapacity, but they can be and pretty much are intended to be temporary. They're not always intended to be permanent. They can become permanent, which is why I tell you to have them as your minimum protection. So they can turn permanent. But when there is a permanent incapacity, so we have lost our cognitive functions and we are fully incapacitated, there's no expectation that we are going to regain the ability to make decisions for ourselves and be able to care for ourselves. Then it can rise up to the need for a legal guardianship where we're not going to go to the probate court in Harris County, the probate court, county court, and other counties, and where we're going to have a court determine a guardianship is needed, and we're going to name a legal representative, a guardian, to step into those roles. What a designation of a guardian in the event of later incapacity does is name that person. Who do you want to be your guardian? And so, and that's effectively what it is. There's 2 types of guardianships. Remember, we kind of have 2 paths. The first one is a guardianship of the person. That's the person who's going to decide the care and health of the ward, medical decisions for the ward. And then there's a guardian of the estate, those financial and legal matters. So that person can be able to do that. Now, they can all be the same person. Your guardians can be the same people as your power of attorneys, or they may be different people. I always recommend that if you're going to have different people for these different roles, be sure that they're going to get along and that you give them instructions and give them in power so that way they can do what they need to do. So that way there isn't any conflict between them. So it's okay if they're different people, but just be sure that they can work together if you are going to have different people. But sometimes, like for examples, things that I might get, right? You may choose a person who's local, who lives locally with you in the same city as you, to be your power of attorney, so your statutory durable power of attorney and your medical power of attorney, because they're going to be easily accessible and quick. But when the permanent guardianship comes into play, you may want to pick somebody who lives in California. It's like, well, no, I picked a child who lives here, but long term, if we're talking about long-term care, ultimately the person who I want to be living with and who's going to be caring for me is my child in California. I'm picking the child here in Houston because they're accessible. They know that they're not going to be the permanent guardian if a permanent guardian is needed. But if I'm in a car accident, they're the ones who are local. They're the ones who can get to the hospital, talk to the doctor, make medical decisions, right? And then, but if it becomes permanent, I'm going to have my child who lives in California serve in that role. So again, individual plan, what works, what needs to kind of happen in your situation. One of the things that's really has important for some people in this document is that you can disqualify a person from serving as the guardian. So what does this mean? This document is not dispositive. What it means is that the court is not required to follow the instructions here. The guardian must be approved by the court. So they have to qualify, and the court has to agree to them serving as the guardian. Now, the court will say, we'll look at this document and we'll be like, okay, well, Bob has been listed as the first person. For whatever reason, Bob has declined. Bob is unable to serve, has, for whatever, like they've declined, right? And he's not available. And so now we go to the second choice person. They're going to look at the second choice, but now they're disqualified. This person's disqualified. They have felony that disallows them from serving, right? And so, well, now this person disqualified. Well, now the first two people, the choices, remember, for every one of these, we're going to pick a person and an alternate. And so now this person is disqualified. So the court can't appoint this person because they can't serve as a guardian. So now they're going to go look at next of kin. What's the next order of priorities that they're going to look at? And you're going to say, you know what? I haven't talked to my brother Jim in, 20 years. He doesn't know me. We've been estranged. We lost touch. He may be my next of kin, but I never want him to serve as my guardian. So you're going to put down that I never want Jim to serve as my guardian in this document, and the court will actually listen to that. So even though Jim may be the next of kin and the person who would be selected to serve as the guardian, because this document says, nope, do not name this person, the court will actually look at that and go to the next person in line to determine if they should serve as the guardian as opposed to Jim. So that can be just as important for some people when it comes to completing this document. HIPAA release. So HIPAA stands for the Health Insurance Portability and Accountability Act. It protects private medical information, and it cannot be shared by certain people without that express permission of the person whose medical information belongs to. It's not everybody. It's only some people. Mostly, what most people think of is hospitals, medical providers, is what most people think of when they think of. But it also applies to like law firms. I am a HIPAA person that I am required to protect medical information provided to me in the course of representation of clients. I cannot share that information without an express written release from my client to share it with other people. And so it's so that's what it is. Now, if you share your medical information with your neighbor Susie can go down the street and share it with Jane. That she is not subject to HIPAA if you share your medical information with her. So it is only certain people. But what a HIPAA release gives that permission to those of us who are governed by it to share that information. And at minimum, your HIPAA release should include your medical power of attorney and your designated guardian of the person. So that way they can get access, but you can include more people to receive that information for it. Just keep in mind, you do need to have this general release, and it is a document that I do prepare for everybody. The HIPAA releases that you sign with your individual doctors only apply to that individual doctor. So if you go to your GP, complete that form, they can only provide the information. You can't take a copy, provide to your GP, and then that person takes that document to a cardiologist, and then the cardiologist is like, no, I'm sorry, HIPAA release was never completed here. That's not sufficient. It doesn't apply to me. So this is a general across the board. So that way, any doctor or anyone who holds this medical information is allowed to share the medical information. Advanced directive to physicians. This is commonly known as a living will. And this is end of life decision making. And there's some, differences of opinion on whether or not this document needs to be completed. I think that it's an individual conversation to have. But where this applies is in two situations. We're talking about terminal conditions and irreversible conditions. A terminal condition is defined as a person is expected to pass from their condition within 6 months, even with available life-sustaining treatments. An example of a type of condition this may include may be stage 4 pancreatic cancer that's aggressive. That would probably be an example of a terminal condition. An irreversible condition is a condition that is not terminable. A person can live with this condition for an extended period of time, but if there isn't an intervening treatment, then it can become um, a terminal condition. So an example of this would be a coma. A coma, people can live in comas for quite a bit of time, for a pretty lengthy period of time. However, we need nutrition, we need uh, water, right? So we would need to intervene with artificial nutrition and feeding. And so that would be, so we would need to intervene at that point in time with the life preserving treatment. And so in each of these situations, there are kind of two options that are available. One is to stop treatment, allow me to pass peacefully, and keep me comfortable. Don't use life-sustaining treatments. And then the other option is to use all available life-sustaining treatment. I would like to go ahead and continue to make the fight, please. And there's no right or wrong here, by the way, right? It's what your belief structures are, your what you would want in those situations. I'm not here to tell anybody what they should or should not do in these things. When you are within the available life sustaining treatment, you can put in specific instructions, and some people will have that. So for example, a person may say, this is actually not uncommon. They may say, yes, please use all life sustaining treatment, but if in the event that I would need to be put on a respirator, then I would like to pass peacefully. So I never want to be put on a respirator. So that would be an example of someone wanting to have a specific instruction. So you can also put something like that in there as well. Now the documents that you see and the templates that you see typically stop at that point. It's typically one or the other, and there's not usually a third option listed. But there is an option to allow the decision to be made by the medical power of attorney after conferring with a physician. And in fact, most of the time, if there is a medical power of attorney in place, the doctors, even with an advance directive, would still talk to the medical power of attorney anyways. And then this would turn into a guidance document as opposed to a decision document. But but kind of keep that in mind, because some people will say, I really want the conversation to have a medical power of attorney because maybe I want a second opinion that there's nothing that can be done. Just know that in the event of that, life sustaining treatment will be used, and then the person may be choosing to make end of life decision making, is what would be being asked of the medical power of attorney at that point in time. Um, th- this is a very heavy document. This can be quite heavy, right? And we're talking about someone who loves you making a decision that they probably do not want to make. And for some people it's not. Some people, they know, and they have these conversations. They may be hard conversations, but it's understanding and things like that. But has the counselor in me, in the counseling side of the legal profession, I do recommend that if it is heavy and this is a hard conversation, talk to doctors about it. If there is a medical condition that we're thinking about, what does this mean? Has it may impact that. If you are a person of faith, maybe your faith leaders, counseling, go to talk to a licensed counselor, a therapist, bring in conversations with the person who would be making the decision, so that way they know what you would want. And again, depending on your own dynamics and needs, offering forgiveness, permission, whatever language that needs to be done to make this easier in the event that this is something that has to happen. Let's hope not, but it is a reality that some of us have to plan for. Um, Now, this does not replace hospice plan. Again, as long as we still have the ability to make our own decisions, we are able to do that. If we enter into hospice, the hospice plan will govern, and the advance directive will no longer have any effect. The next document is a very specific document, which is a declaration for mental health treatment. This is known as a psychiatric advance directive. This is when a person who's at risk for a history of psychiatric hospitalization, thinks people diagnosed with schizophrenia, and has an example. And so this document is decisions in advance as it relates to psychoactive medication, convulsive therapy, and emergency mental health treatment, such as restraints and seclusions. This is not something that everybody needs. Again, it's only for people who have that risk of psychiatric hospitalizations. But if you are a person or know somebody who does have this, has a risk for them, this is a really important document and highly recommended that they consider putting it into effect before they get hospitalized. Unlike the other documents where you kind of update them as a need goes, these documents expire. They expire every 3 years and have to be re-executed. So now we're going to switch over. I know we only got 15 minutes. I got a lot to cover. And so, but those are the big ones. Those were all the big ones. Everything gets a little bit quicker here. So caring for those in our care, incapacity, unavailability. So two different kind of things. We are no longer able to care for them because we cannot care for ourselves, right? We're no longer available, or we have passed, and those in our care, we have passed. And so now we're not around to be able to do that. But it also includes people who, when you're just not available. And using myself as an example, when I was growing up, my dad worked overseas quite a bit. He was an oil man, or worked in the oil industry. And so where there was oil, he worked in that country. And so, so he was just out of the country, and maybe he needed some of these documents to be put into play. I mean, we didn't, but it's like, but that would be an example of like where a parent may not be available. So they've put some documents into place to be able to care for the child who is when the parent is unavailable. And so that's kind of what we're talking about here when we're talking about caring for those in our care. So one is in your will. Typically the surviving parent becomes the primary custodian of the children, but in the will you can name a custodian in the event of passing, and the other parent is unavailable, or cannot serve as the custodian for whatever reason. So you can put that into the will. It also will be part of the designation of a guardian in the event of later incapacity. You would naming a successor guardian. So if you are the guardian of a person, you can draft this doc. So one, you've done one for yourself, and then you will draft one as the current guardian of someone for a potential successor guardian. Again, just like the one where it's a guardian for your success for yourself, it's a suggestion and recommendation to the court. The court will take it into high consideration, assuming that the person can be appointed. They will get appointed, but otherwise, it will they have to go through that same similar process. So that's what makes this quick, is that we've already talked a lot about these other documents, and so those are kind of things that you can do. So first one, right, planning for your passing, planning for your incapacity when they're in your care, and then the next one is kind of when there's unavailability. So this is an authorization agreement for voluntary adult caregiver. These are non-parents. Obviously, parents have their rights and that they can make decisions. So we are looking at non-parents. This includes grandparents. So grandparents making, when we got that extra, or potentially a neighbor, who knows, right? I don't know your family dynamics, all about you. But it's someone who isn't a parent who can care and make decisions for a child without a court's permission, without having to go to the court. And there's lots of different types of permissions that this can include: medical treatment, insurance, enrolling them in school and daycare, and extracurricular activities, driver's license, giving permission to get a job, applying and receiving public benefits, and obtaining federal and state identification documents. So it's a lot. Like, this is huge. Like, it's more than just picking them up from school, right? So there's a lot of different powers and permissions that you can give to this person to be able to do that. Really important document for people who need it, and then to be able to plan for that. If in doing this type of a document, you would want to be sure that in addition to the document, as part of preparation, you would want to prepare a family binder that includes all the information that person needs, depending on the powers that you gave them, which may include information about medication, household, financial information, if they need access to financial information, contact information for family members, and things along that lines, right? So you would want to put all that together to your emergency family binder. Not emergency, but your family binder. If there's a court order in place as it relates to the custody of children, typically that does require court permission to do that. But you should consult an attorney to know exactly whether or not you can draft this document when there's a court order in place as it relates to the conservatorship or custody of a child. Okay. All right. Then, and the last document that we would talk about here is the child travel authorization letter. So as you see in all of those lists of powers that I gave you, not one of them talks about traveling. That one requires a separate document, which is the child travel authorization letter, also known as parental consent to travel form. It's a separate document that gives permission for a minor to travel with a non-parent adult. It is very much needed by immigration authorities, airlines, and border officials when we're crossing international borders, so that obviously for the sole and intense person of protecting our children, right? So, but if when my dad was over in one of these other countries, and my mom wanted me to go visit him, and she couldn't be the one to take me, she would complete one of these forms, and I would travel with whoever the person is that I would be traveling with, right? So that would be an example of when you would use that document. Okay. Long-term care planning can be its own 2-hour presentation. When we're talking about long-term care planning, we're talking about us as an aging population and preserving our estate in the event when we need to have medical care as we age. So we're talking about becoming eligible for benefits such as Medicaid and protecting assets from creditors, which include the Medicaid Estate Recovery Program, commonly known as MERP. This is again very individualized, and there's more than one way to kind of preserve the property and become eligible. When it comes to real property, there's two things you can do, which is one is known as an enhanced life estate, commonly known as a Lady Bird deed. For years, this was kind of the I wrote Lady Bird estate. Sorry, this is a Lady Bird deed, and used quite frequently for many years, which is transferring property and retaining a life estate. And but the reality is that for a lot of people, the transfer on death deed also serves the same type of protections. And so again, depending on the specific needs that you would have, it could it could be either a ladybird deed or a transfer on death deed, and it would have a similar kind of protection. So so when we're talking about real property, again, individual, what's going on. And then when it comes to income, so if one spouse needs to get onto Medicaid in order to be able to get long-term care or nursing home benefits, but the income from the household would make that person unqualified for those benefits. Because this one spouse is working, we can do what is known as what is called a qualified income trust, commonly known as a Miller trust. This is an irrevocable trust. Once it's made, you cannot undo it. But that the income goes into the Miller trust, and that allows for the spouse who needs the benefits to be on Medicaid are able to get the Medicaid benefits. In both of these situations, you should consult with an attorney. There's different times to think about it. When it arises, when the need arises, is you can talk to an attorney about what the options are at that point in time. But sometimes people know it's coming. If there's a family history of dementia and you know that and you want to anticipate planning for that, and some people do have that history and they know it's coming, they can prepare for that. I mean, let's hope not. Medical science is wonderful and there's all sorts of innovations that can happen, but sometimes people are like, you know what, grandpa had it, dad had it, I'm assuming I'm gonna have it, right? And it's like, so it's that but you should discuss these options with an attorney, but they can get pretty complicated. Okay. All right. I know that was a lot in that last bit, but I hope that you heard that a lot of it was a little bit repetitive. This can be overwhelming. The good news is that help is available. So this is our website and our phone number that you can call to do that. So I did have a question about applying for assistance with Lone Star Legal Aid. We do have a website. If you are comfortable getting onto the computer or have someone who can help you, it's probably the fastest way to apply for assistance is to go online and do it that way. Sorry, talking too much without a drink. Excuse me. Um, That's also our 800 number that you can call and do that. If you are inclined to do so, we do offer some walk-in hours. It's not, that may not be the fastest way, and driving downtown it can be complicated, parking can be difficult, but so I do recommend to give us a call or apply online in terms of being able to do that. And to answer the question, there was a question about whether or not we provide estate planning services. We do apply. You can ask for estate planning services. That comes to my office. That would be me. That would be me. That would be kind of handling it for most of them, not all of them. But so yes. So just go ahead and complete the application. And when you get to the problem, what you need, just say that that's what you need is a will. You can pick a will or an advance directive. There are other agencies in our partnership, as you can see in the giant logo behind Miss Nia. She will send you all of the other contact information. I'm just being selfish and hope you come and see me. So, but my partners at our partner agencies, I am friends with them. I know them. They are wonderful people. If you choose to go see them, it's okay. I won't be bad. But that's just me kind of being self-serving in some degree. There's some upcoming programs that Miss Cell mentioned at the beginning, and I mentioned, so next week is going to be the series, which is talking about clearing title to inherited property. If you did come here hoping to learn more about what to do because you have a person who has passed and you're not sure what to do next, please go and attend that session. And some of those questions will be able to be answered there. We do have our coffee and conversation resource fair at the A-Leaf Neighborhood Center on Tuesday, April 22nd. I will be there with my team. We will be accepting applications, and we work with volunteer attorneys in the private bar who do this for us. And so if you are eligible for services, you will be working with some of my wonderful volunteers to do that. But you can come and see me in person. If you prefer not to apply online or via phone, you want to come in person, come see me at A-Leaf there. And then again, as I said, part 2 or series 2 in this series, how to draft your own will and transfer on death deed. That will be next month on Thursday, May 1st, same time, same bat channel for those of us who are in the know. And last but not least, I always like to end on a funny. This is a very heavy topic. I try to make it light. I try to make it informative and a little bit easy for everyone to do, but I like to always end on a joke. And so this is my little comic, which is Miss Hen has gone to see her attorney that says, I want to leave all of my estate to my sister, but if she's not living, then in trust for her eggs. There was a question about the rewatch. Yes, Miss Nia will send you a link to the video, so that way you can watch it again, because again, lots of information. So with that, I'll hand it back to Miss Nia. For anyone who has questions, if you'd like to unmute yourself, feel free to do that or put it into the chat. Happy to answer questions at this time.
All right. Along with the video, I will also, as Jesse mentioned, be attaching the copy of the templates so that you can kind of follow along and go along and look over those documents as you're reviewing what she has provided as well. So thank you, Jesse. Again, a lot of information covered here, so don't be afraid to come back next month, or if you think about, oh man, I should have asked this question, or I didn't think about this. Feel free to come back and join us next month and ask. Now, I did have a question. You did answer the questions as you were going along in the chat, so I don't have any there, and I don't have any that are online. But one question that did come up last month at the inherited property presentation: what does someone need to do beforehand? I don't know if you can answer this or know of a type of attorney that they need to contact. If somebody's got a small business, if they have an LLC or if they have a sole proprietorship or whatever, and then they pass, what do they need to do to protect that business assets or whatever to pass along to the family?
Yeah, so business succession planning, it does depend. It depends on the business itself and like what's going on, right? And so I'm not like an expert in it, right? Like just being honest, but it would be like there are things that you can do, you can put into place, and so there are agreements, there are succession plan agreements that on who would inherit the property that's put into place prior to the person passing, and to ensure like partners can get it or who's gonna, so there's documents that can kind of put into it can be in the will, like if it is an individually owned business, it's
Mm-hmm.
and they have equipment and they wanted to go to their son who's been working with them, but they basically have not really created a business. It's kind of like like a very informal business, which do exist. Probably don't recommend it always, but it's a lot of what would be called Schedule C employees, right? Like you're making money but you don't necessarily have a formal business entity with its own tax number or things along that lines. That can be passed in the will as well. So it is something that's specific, and I would recommend that if you do own a business, whatever kind of category it is, to talk to an attorney about that. But the more formal the business, the more structured it is, more partners or LLCs or corporations, things like that, there's usually its own level, own type of succession planning that occurs there.
Okay, so what type of an attorney do they need to contact about that?
You can talk to an estate planning attorney or
Estate
your
planning, okay.
attorney to help incorporate the business.
Okay, all right, got it. Let's see. Just kind of double checking and going back to make sure. Um, the schedule along with the link and the templates will also be included so that you'll have the entire schedule for the month of April. The other presentations that are going to be available to you guys as well will be included. And I believe that is it. Jesse, you actually finished early today.
I know, only 2 minutes, but
Again, we know that this was a lot of information for you guys, and we don't want you to be completely overwhelmed. But just kind of be familiar with what needs to be done. I try to remind people that if nothing else, that COVID should have taught everybody something that these things need to be put in place, whether it's some kind of payable on death beneficiary, some type of a guardianship, some type of power of attorney, if something needs to be put in place because as folks were, in hospitals and can't make decisions and can't get bills paid and things like that, families were going without. They had no access to bank accounts and things of that nature. It's just something that you really just don't think about because you're going on your day to day and just either some families either just don't want to talk about it or they just really don't think about it because they're just kind of doing everyday life in. So yeah, so have the conversations with your family, so that they are aware also that nobody's kind of caught off guard at the end or not knowing where to go or to find certain documents and things like that. Communicate and let them know what's what and what's where. I had an instance and Miss Jessie was very helpful for me in my situation with my dad. Um, I couldn't even figure out where his bank was. I had his safety deposit box key and didn't have a clue as to where the location was for the safety deposit box. So I had to go shopping around town trying to find a safety deposit box. But then I had the bankers not want to talk to me because my name was not a signer on the account, even though I had his key. Who knew? So there was that whole other process. So there's a lot of things that need to be put in place to make sure that your families don't go into um, get into these kinds of situations and not be prepared and not properly planned. So keep that in mind. But again, thank y'all very much for coming out and joining us this afternoon. If this is your first time here, we hope that you all got the information that you needed. If you need to come back, again, join us. Please feel free to forward this information, pass it along to your neighbors, your coworkers, your other relatives who will also need this information and find it to be beneficial as well. So thank y'all very much for coming. Hopefully we'll see you next week for part 2 of the inherited property for clearing title and other probate concerns is next Thursday at 1 p.m. Let's see, what else do we have? Yeah, that's it. That's what we got for next week. So hope to see y'all there. Ms. Jessie, thank you very much this afternoon for coming out. You all have a wonderful remainder of your day. You take care of yourselves and stay safe, and we'll see y'all soon.